Good afternoon, one and all. At the onset, I thank the organizers for giving me an opportunity to be a part of this seminar. So the topic I selected for today's discussion is sexual harassment of women at workplace, a legal perspective. My co-author is with me, Dr. Krishna sir. And it specifically relates to this particular topic, sexual harassment of women at workplace. And I think she has given already an introduction to this topic. So before entering into the main topic, let me introduce what is harassment and what is sexual harassment, what are the reasons why sexual harassment is prevalent in our society. So when we consider the harassment, that particular concept, and it relates to a particular person's conduct or behavior. The behavior or conduct of a particular person may be an offensive one or an irritating one, and sometimes it may be derogatory or disrespectful. But all these acts are not prohibited in law. Some of the acts or contexts or behaviors of persons are prohibited in law because the law think that it is offensive. And these acts can be considered as illegal because it is prohibited under law and it is an illegal one also. And this harassment may be a form of sex discrimination. And we all know that in our society, sex identities are existing. And some sections of people believe that we are supreme and we have some assertive character and it is a normal one. And because of this, by achieving or by believing this particular concept, they exert violence on other sectors. And so from this it is clear that harassment may be a part of sex discrimination, and that's the reason why we can say that it is a human right violation also, because it violates some of the basic rights of the individuals, that is dignity, equality and right free from sexual discrimination or any form of discrimination, gender discrimination, etc.
As she has earlier said, Article 51A, Clause C, capital A, Clause C says it is our fundamental duty to protect the dignity of this person.
So the next one is, I identified these are the reasons why sexual harassment is prevalent in our society. We all know that the society has assigned certain roles to man and woman. And there is no need of explaining what are the traditional roles of man and women. So what are the consequences of this particular concept? Because it played an important role in shaping the social norms and expectations. And some section of the people may be expelled from social, economic and cultural life, and they may be subjected to different forms of, they may be, so there is a chance of denying equal opportunities to them. The second one is power imbalances, and there are different types of power imbalances existing in our society. The most important among them is economic dependency. And traditionally or historically, women have no right to hold the property. Inheritance rights are prohibited. They were not enjoying equal rights in inheritance rights. Moreover, and in many legal systems, there is no concept of matrimonial property, and based on which they can exercise right on the property actually during the pendency of the marriage after divorce. And the third and most important among is social stigmas, code of silence, etc., etc. So here in this case, we can say that one of the disturbing factor against sexual violence is that there exists a code of silence in society and family. And the victims are not ready to come forward and say what was the incident happened on her. And the public is also not ready to address these problems. And the victims they are not ready to come before the court, before the society, because of the feel that they themselves feel ashamed because of the social stigma existing in our society. And moreover, they feel that their family will be embarrassed. And so because of this, the victims they feel they have to suffer themselves in isolation. But at the same time, the perpetrators, they get that opportunity to do the same again and again because of the belief that it is accepted. And the last one is life. We all know that the life of the girl child is at the mercy of others. Even though if there is no law for prohibiting the identification of female fetus, and the parents, because they believe that because of the prevalence of dowry system and the belief that they will become the member of another family, etc. Because of all these beliefs, and they try to avoid the birth of a female child. And from this, it is clear that many women are subjected to violence throughout their life. They may be assaulted, raped, or battered, or they may be subjected to domestic violence. So these are the reasons why sexual violence is prevailing in our society. So the international community's attention attracted to this particular concept, and the UDHR, that is Universal Declaration of Human Rights, and International Covenant on Civil and Political Rights, even these documents did not recognize sexual harassment as such, but the different provisions of this document says that every person has the right to work without any discrimination, and CEDA, that is Convention on Elimination of All Forms of Discrimination Against Women, it is considered as the Magna Carta of Women's Rights. And this document says that it is a duty of the state to eradicate different forms of cultural and social conduct of men and women, and to avoid stereotyped roles of man and woman. So in this context, let us go through the objectives of my study to find out why we need a specific legislation for sexual harassment, and to find out effectiveness of legislation in India. Third one is role of judiciary in preventing sexual harassment. So to find out what are the challenges existing in the present legal system. So why we need a specific legislation? That's the first question we need to answer. Because as I said, there are certain traditional roles to man and woman, but over the period of time, because of the increasing access to education, the women come forward and started to enjoy different working environment, and there may be, and in this work, being a workforce, they may be subject to different forms of discrimination. It may be a sexual discrimination, and because here in this case, workforce in the working place, they need a specific legislation because it is not the working place is not the option of a woman, and she is forced to come and do her work in a particular working place. Sometimes her promotion, advancement and retention of job or renewal of contract, etc. may be within the hands of the male superiors. They may demand sexual favors, but she is not she may not be in a position to satisfy the needs of the superiors. But still then, because of the ground that she may be the only breadwinner of the family, or she may be she may need some money for her existence, etc. Because of this, all these grounds pressurized her to stay and do work in that workplace. So that's the reason why we need a specific legislation. There are a number of legislations are there in our legal system. So the legal system prevents assault and use of criminal force to the outrage the modesty of the women, and use of word, gestures, etc. which are used with an intended to women. All these are prohibited under the Indian Penal Code or Bharatiya Nyaya Samhita. But these protections are available only to the women who are at the public place. But special legislation is needed in workplace, and this has been recognized by the court in Vishaka's case, that was in 1997. And in this case, the court recognized that there is no specific legislation for addressing sexual harassment of women at workplace, and there should be a legislation, and based on which it introduced certain guidelines, and it is known as Vishaka guidelines. And the court invoked the international conventions for introducing this legislation, and it was introduced as a temporary measure. But after 16 years, the parliament enacted a law which is known as Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, and it is known as POSH Act. So what are the main objectives of this legislation? To provide equality and dignity in environment. Second one is protection from sexual harassment. Third one is provide an effective redressal mechanism. And the fourth one is prevention of sexual harassment in workplace. There are different instances which are recognized by the legal system as sexual harassment. Sexual harassment not only includes verbal characters or verbal the words, and it also included within it non-verbal, psychological, emotional and other aspects of sexual context on the part of the employees or other members within the workplace. And all these are different instances of sexual harassment, and this act has given a wider interpretation to sexual harassment. It includes within it quid pro quo harassment also, because the employer offers something in favor of satisfying sexual harassment. So what are the favors which they may offer? That is maybe promotion, renewal of contract, special preferences in job, etc., etc. So, and moreover, creating hostile environment is also a sexual harassment by spreading different types of gossip against women. That is also come within the purview of sexual harassment. So workplace includes within it both government institutions, non-government institutions, then organized and unorganized sectors, etc. And this right is not given in the normal workplace only, but also in other places, in transport facilities which are provided by the employer, or in the place in which she visits as part of the employment, etc. All these are included within its purview. And the sexual harassment commits within the virtual platform is also included by the court as a workplace. And in Jahid Ali versus Union of India, the court has taken the view that the WhatsApp is also a part of workplace. So complainant, and this protection is not only available to the employees within the institution, but also unorganized. The person who visits the workplace is also protected under this act. And this act provides two important mechanisms for redressal. First one is internal committee, and it is an in-house mechanism. And second one is local committee. This committee exists at the district level. And this committee has jurisdiction to hear the complaints against the employer, against if the complaint is filed by the domestic worker. The right of the domestic worker is also protected under this act. The third one is that certain institutions are not bound to establish internal committees, and the sexual harassment at this workplace can also they can come forward forward to the local committee to satisfy their redressal. So interim remedies are also available to women during this period, and the procedure is also, and it is a time-bound procedure is prescribed. The committee has to complete the inquiry within a period of 90 days, and the employer is bound to implement this decision within a period of 60 days. So these are the procedures which are given by the legal system. So what are the different types of punishment which can be imposed on a perpetrator? This conduct can be considered as the sexual harassment can be considered as a misconduct, and it is so they have to take certain action under the disciplinary the conduct rules. Conduct rules. So based on the contract rules, the employer can deduct salary or deny promotion, increment, etc., etc. If the sexual harassment comes within the purview of any of the offences under the IPC, they have to face different consequences. So for the prevention of the sexual harassment, these are the duties provided to the employer. It is the duty of the employer to provide a safe working environment and provide assistance to the woman who is suffering sexual harassment, and monitor the timely submission of report, etc. All these are the different the duties of the employer. So what are the challenges existing in this situation in the present legislation? So here in this case, no compulsion for the constitution of redressal committees. The Act says that the employer, if the employer fails to establish a committee, they have to give 50,000 rupees, and but there is no efficient mechanism for finding out whether they are constituting or establishing these redressal committees, etc. These committees are only ad hoc, and the rights ensured to domestic workers, and it is not properly mentioned here. committees have the committees are enjoying a civil courts power, but there is no expert or professionals in these committees, no provision for counseling to the aggrieved woman, and the harassment based on, and here in this case the protection is available to a woman if the harassment relates to it must be a sexually colored one, and so certain gender based comments or discriminatory approach from the employees cannot be addressed to these type of legislation. So what we need through this particular legislation and through different types of amendments, we can improve the present legislations, and what we need today is a healthy working environment. And with this comment, I conclude.
Ma'am, can I ask a why we are not giving death penalty in rape cases?
Actually, this is a very good question. This question has come before the committee constituted for making Indian Penal Code, headed by Macaulay. So he has well explained this query. See, for capital punishment, for murder cases, the punishment prescribed is capital punishment, that is death penalty. If suppose he impose the punishment, same punishment in rape cases also, what will happen? Naturally, the perpetrator will have a tendency to finish the lady or the victim, right? So, it is not at all advisable to insist for capital punishment in rape cases. That may be the reason why we have said. Yes, okay, sure. No.
That contradicts Article 21.
So Article 21 says that no person shall be deprived of his life and personal liberty except according to the procedure established by law. So there should be I'd say legal questions as are asking is, so before at the time of finding out whether a person is guilty or not, there is a procedure, and that procedure is prescribed within the CRPC. But in between the finding of guilt and imposing of punishment, in the case so in the case of I will answer you in person. Okay. Thank you.
Thank you, sir. Thank you.
Thank you.